Welcome to Cocktail Copter Weekend Explainer, where we are focusing this weekend, the whole of Saturday and Sunday, about family. Not during barrier disputes, but family in terms of the following issues. Are you a mistress? Are you cohabiting with somebody, but you don't intend to marry each other? Have you been in a relationship for convenience? Nowadays, the young people are not getting married, but they have their fiancés, they have their own mubabas, they have their own people. They are staying together, but they will never solemnize their marriage. There's nothing called marriage. The Gen Z will tell you they don't take pregnancy. They don't give pregnancy and they don't take pregnancy. They're just living. There's a new crop of a relationship. Girls at the university, they are staying with somebody, but they are not going to marry each other. Boys at the university, they are staying in the hostels with a woman, but they are not going to marry. Young professionals who have finished university, finished technical colleges, are staying with the opposite sex in one house, in one room. They have no child. They are not intending to marry. Widows, nowadays, there was a time when widows were being inherited. Today, the widow will not inherit each other. You remember what happened to Nelson Mandela? Nelson Mandela, after he divorced Winnie Mandela, he went and started staying with Gracia Machel, the wife of the former Mozambican president, Samora Machel. But then it went up to there was a marriage. That was the old generation of Nelson Mandela. Today, how many people marry? Very few people marry. How many people have children? They don't have children, but they are staying together. These people buy properties together. Sometimes they apportion 50-50. Bramwell buys a TV, Lillian buys a cooker. Dunstan buys a sofa set, Malonza buys a carpet. That is the new arrangement that is there. Look at the apartments that we have all over in Nairobi. People of different sexes are every day driving out of those estates. Those estates have no balconies because children are not there. The design of the buildings has changed. Originally, there were buildings that children could be there. All those apartments, you don't see a child coming out. My friend Bramwell has even told me one question, that he has never seen a pregnant woman. If one, it is aspect. When did you see pregnant women? One. Very rare. If you go to the village, yes. But here in town, which woman is pregnant? So the question is, all these women are staying with men. All these men are staying with women, but there is no binding agreement. These people can stay for 20 years. Nobody has any document called a marriage certificate. They owe nobody any responsibility. They have no families. They have no children. But they have invested together. So when there is an issue after they have differed, how will a woman get a share of the property? How will that man get a share of their property? This is our landmark issue because over 70% of the people below 40 years are living together, but they are not married. Let us talk of a new generation of husbands. husbands who have not divorced their wives, but they have packed their bags and left. They have gone to stay with another woman. They are not married. They are not having their children. They are staying together. But this person is lawfully married to another woman. What happens? This was the question that confronted the Supreme Court of Kenya. And the Supreme Court of Kenya, in the case in the Republic of Kenya, the Supreme Court of Kenya, that is petition number 9 of 2021. The judges who are hearing this matter is the Deputy Chief Justice, Justice Mwilu, Justice Wanjala, Justice Njoki, Justice Lenaola, and Justice Huko. This is a decision that was issued in 20. This is a decision of 27th day of January 2023. This is a matter of Mary Nyambura Kangara, alias Mary Nyambura Paul, the petitioner, versus Paul Ogari Mayaka, the respondent, and Initiative for Strategic Litigation in Africa, ISLA, as an amicus. The question was put before the judges. Here, these people invested together. They stayed for so long. They stayed for so long, but there was no law saying there was a presumption of marriage. So the Supreme Court, in paragraph 64, looked at this case. These people had stayed together for a very, very long time. But can they be presumed to be having a presumption of marriage? Remember, the presumption of marriage died. Nowadays, there are only 5 marriages. Either you're married, a Christian, that is a Christian church marriage, a civil marriage, a Muslim marriage, a African customary marriage, or the Hindu marriage. So the court found out that these people have developed a new type of relationship. Listen to what the judges created, a new type of, and defined that relationship you have said. In the same breath, we would be remiss if we did not point out that marriage is an institution that has traditional, religious, economic, social, and cultural meaning for many Kenyans. That is not the question. However, here is where the judges now brings you thunder. However, it is becoming increasingly common for 2 consenting adults to live together for long durations where these 2 adults have neither the desire, wish, nor intention to be within the confines of matrimony. This court, the Supreme Court, recognizes that there exists relationships where couples cohabit with no intention whatsoever of contracting a marriage. In such contexts, such couples may choose to have an interdependent relationship outside marriage. While some may find this amoral or incredible, it is a reality to the times we live in. The Supreme Court has created a new type of marriage called interdependent relationship. That the boy and the girl, the man and the woman, the mzee and the mama shosho are interdependent. But they are not married. What does the judge say? The judges in section 67 says, for instance, a person may have been in a marriage before and the marriage is no more due to death of a spouse or divorce. Due to their prior experiences, such persons may choose to have an interdependent relationship outside marriage. For others, it may just be their desire never to marry, but have a partner without the confines of marriage. Where such situation is evident and there is no intention whatsoever of contracting a marriage, the presumption of marriage must never be made where this intention does not exist. It must always be remembered that a marriage is a voluntary union. As such, courts should shy away from imposing marriage on unwilling persons. So the courts are saying, don't start saying these people, because they have stayed together for 20 years, there's a presumption of marriage. Ask them, the two, did they have a mind to marry? Their mind was to depend on each other. Their mind was to enjoy each other. Their mind was for convenience, not for marriage. So you cannot start saying there's a presumption of marriage. The courts are moving on. In paragraph 68, it says, in addition, in our ever-changing society, the courts are alive that society is ever-changing. Current statistics reveal that a man and woman can choose to cohabit with the express intention that their cohabitation does not constitute a marriage. The pervasiveness of having interdependent relationship outside marriage over the past few decades means that no inferences about marital status can be drawn from living under the same roof. Interdependent relationship outside marriage is not a new concept. It is an old concept. It is gaining momentum in Kenya. What did the judges say? In paragraph 69, in Alberta, Canada, it has been there since 2003. There is even a law called Adult Interdependent Relationship Act in Canada. What did the judges do? In this regard, the Supreme Court gave a recommendation. What recommendation did they give? In this regard, perhaps it is time for the National Assembly and the Senate of Kenya, in collaboration with the Attorney General, to formulate and enact statute law that deals with cohabitees in a long-term relationship, their rights and obligations in a marriage, in a relationship called interdependent relationship. So the Supreme Court has recommended to Parliament, has recommended to Senate, has recommended to the Attorney General to make a law that deals with such people. It moves on to say, whenever two parties by their joint efforts acquire property to be used for their joint benefit, the courts may impose or impute a constructive or resulting trust. The legal owner is bound to hold the property in trust for this person. So the questions that are there, when these people are living together, they are doing contributions together, they are investing together, they are thinking together, they are toiling together, they are saving together. What happens in this matter? The case in court was that Mary Nyambura Kangara was the person who had more properties registered in her name. Paul Ogari Mayaka was thrown out. So Mayaka went to court and argued that, wait, just wait, no. I have a share in this property. This sofa set, we bought together. This car, we bought together. Mary said, we never married each other. You are just a cohabitee. Remember, nowadays, most men are being housed by women. Justice Wakiaga calls them the women eaters. Most of our young men cannot pay rent for their own houses. They moved to stay in the government. This is similar to that story. So the battle was, can the property acquired during this relationship be dealt with under the family law of division of matrimonial property? The Supreme Court made this finding. So don't think you have lost your property because you are in an interdependent relationship. Don't think that you will lose your property because you are a mistress. Mistresses under the law of division of matrimonial property lost everything. But now we have a law from the Supreme Court. I think the mistresses, those cohabiting, those visitors, women are called, they are visitors who are invited in Omari's house. They overstayed. Now they must go. And they go without anything. My good sister, if you have been a mistress, cleaning the house, cooking for your boss, cooking for your man, washing his clothes, he cannot leave you without property because he now thinks he'll chase you and because he has seen a new woman in town. What did the judge therefore say? We therefore make a finding that the share of the parties is apportioned as 70% for the appellant and 30% for the respondent based on their respective contributions. So the judges they shared the property of the cohabitees. The mistress got a share. The cohabitee got a share. Therefore, court helicopter now brings it to you. You cannot dispossess a mistress. You cannot dispossess a concubine. You cannot dispossess anybody because you are telling them that, boss, there's no marriage certificate with you. So long as they will prove they stayed with you for long, there was no common intention for marriage. If there is no common intention for marriage, you cannot bring it now. That's what the judges are saying. From the day you started living, you people had agreed that we are not going to marry each other. And therefore, you can now not start telling one of them that, but where is the marriage certificate? Me, I didn't marry you. So the properties that were acquired on the understanding that we are not going to be married shall be shared according to each person's contribution into that, those buying of the properties. Wakili Dan Senomari getting it to you from Court Helicopter. We wish you a good Sunday because our job is to teach you what the law is. See you in the next episode.